Hello, everyone. My name is Joshua Medina, and I am a member of the legal team and the pro bono coordinator at the National Crime Victim Law Institute. Let's talk about these words for just a moment. What is the most important part of this title? Let us know. Now let's hear from NCVLI's Executive Director, Meg Garvin, for the answer.
It is the apostrophe on the victims. Victims apostrophe S rights or S apostrophe rights. And the reason that we start there, when you're thinking about victims' rights, an introduction to victims' rights, how do you make them meaningful? And particularly, how do you make them meaningful through litigation? It is the apostrophe that matters because the apostrophe is ownership. In the English language, in our grammar, right, apostrophe means it can be a contraction, but in this situation, the apostrophe is ownership. If you ever see victims' rights written without the apostrophe, right, someone just might not have thought about it, but this is your opportunity to start the discussion about what victims' rights really mean. And it means the victim owns them. And when a victim owns a right, or if anyone owns their right, whether it's a defendant, whether it's an environmental litigant, whether it is an LGBT person fighting for civil rights, when they own that right, they get to choose what to do with it, when to do something with it, and if they even want to do something with it, they own it. So in thinking about victims' rights, and in reflecting on your own organizations or in your own litigation, really start with a foundation of punctuation. If we start really focusing on the apostrophe in our common discourse, in our litigation, in our briefing, then folks will start to say, I need to ask that victim what they want to do with this right to be present. Do they want it? Do they want to waive it? I have to ask this victim if it's okay if I share their information because they own the right to privacy. So that's a really non-litigation focused moment in some ways, but as someone who was trained very intensely in English grammar and in language and who holds language near and dear, I find that an incredibly powerful starting point of this conversation is that apostrophe.
So we know the rights belong to the victims. Let's continue this conversation by talking about when the modern version of victims' rights really came into being. Looking back a few decades, victims started to be excluded from the criminal process with the rise of public law enforcement and prosecution. This exclusion peaked in the 1970s. The rise of victims' rights in the 80s and in the 90s was a response to this trend. Since then, victims' rights were passed all across the country. Here's a question for you. Today, every state, as well as the District of Columbia, has statutory and rule-based provisions. We have established that victims' rights exist all across the country. This is what the common victims' rights look like. The right to due process, fairness, dignity and respect, privacy, to confer, notice, to be present, to be heard, speedy disposition, and restitution. It's crucial that attorneys working with victims know how the provisions discussing these rights are worded in the victim's jurisdiction. To understand the construction of victims' rights laws in a given jurisdiction, we need to look to the sources. Let's hear from NCVLI attorney Terry Campos about where to find victims' rights.
Where do we find victims' rights? And again, this may be review for those of you who took the Intro to Rights Enforcement. It's really, really important to really keep the hierarchy of laws in mind when you're doing victims' rights litigation. And that's because, as all of us know from watching various TV shows, because we hear Miranda warnings, we know that a defendant has a right to an attorney. We know that they have a right to remain silent. These are all founded in the United States Constitution. What does that mean? Well, that is the biggest law there is. So if somebody has a constitutional right under the United States Constitution, that is going to be the most important, powerful right. So with courts knowing this, right, with everyone in the country having this understanding that defendants have these United States constitutional rights, we need to be really careful how, when we're litigating victims' rights, to use the highest, most powerful right that we can find for the victim, because we want to be able to say, you know, these are important as well. And to counteract that kind of knee-jerk reaction that defendants have these really powerful rights and there's nothing that's going to overcome them. So we always want to look to the United States Constitution first to see if the victim's rights can be found there. And it doesn't have to be explicit, right? The right to privacy, an individual's right to privacy is not explicit in the Constitution, but we know that there is that right. So we want to be sure that we capture all those. So we look there first. And then we go down to the whatever state you're in, your jurisdiction, you want to look to see if there's a state constitutional right, because that would be the next highest, right? And then you go to your statutes and your rules and your case law to see what is out there that you can use to help enforce the victim's rights. Or to find those rights that you can then utilize in court to help your victim participate to the manner that they want to in the criminal case. Now, one thing I want to caution too is this is where you can find victims' rights, right? So you might have a state constitutional victim right amendment. You might have a state statute that has victims' rights, you know, spelled out explicitly, but that's not the only place where you can find tools to argue for victims, to give them participation in the process, to fight certain things that are coming at them, like defense motions, continuances of court. You can always look to other places. So for example, what do I mean by that? Well, for example, you can look to a state's discovery rules, right? You can look to that and say, hey, defendant, you're doing something that's outside the state discovery rules. You're not authorized to do this. So it's not necessarily even within a victim's rights statute or a victim rights, but it would enable you to argue on behalf of the victim, defendant, you don't get that evidence that you're seeking from the victim because we're in discovery stages. And if you look at your state law, you don't have a right. You're not authorized under the state statute. So when we're looking at where to find victims' rights, big picture, look for the highest, the best, the biggest, know if your state constitution has a victim's bill of rights, know that whether or not you have a state statute that covers it, then also expand your horizon. Don't limit yourself to just that. There's many, many tools that you can use to argue for victims when you're in a criminal case.
With that information in mind about the sources of victims' rights laws, let's look at some examples. For the first example, we will explore this federal statute. Here's Meg Garvin with more information.
If you look at those rights that are articulated there, to be reasonably protected from the accused, reasonable, accurate, timely notice of court proceedings, to not be excluded, full and timely notice, confer with the attorney for the government, reasonably heard, proceedings free from unreasonable delay, and to be treated with fairness and with respect for dignity and privacy. Those same foundational rights exist in almost every jurisdiction with just some slight tweaking. These rights, these 8 rights that are articulated in the Federal Crime Victims' Rights Act, the CVRA, can be leveraged to do so much for victims.
Our next step is to look at an example of an individual state's victims' rights laws. For that, we'll zoom into California and hear once more from Terry Campos.
So here's an example of what those constitutional victims' rights amendments may look like. And you can see that they cover all those general categories that we showed on that tree: the right to protection, the right to restitution, the right to privacy, all of those things, but they've become really kind of more specific. And not every constitutional amendment is going to be this specific. California has some really specific provisions in their constitution, but that doesn't mean if you look at your state constitution and it doesn't get this specific, if it just has just a couple of, you know, the right to be treated with fairness, dignity, and respect, or has a right to notice, and you're like looking at Californians and like, wow, they have a right to refuse interview, deposition, or discovery requests. We don't have that in our constitution. Well, you may not need that explicit provision to be able to still argue for your victim that they don't have to be deposed by the defendant, that they can refuse a discovery request, because you may have a right to privacy, right? that's explicit in the Constitution. And if you don't have it explicit in your state constitution, you still have the federal constitution to argue that. So don't be turned off if you look at your state constitution and it's not as if it's not as broad, or what's the word I'm looking for? It's not as expansive as California's. We use California as an example because it really has kind of thought a lot about the various ways in which these rights might come up, and they've been very specific in some of these situations. So it's great and it's awesome, but that doesn't mean if you don't have all that, that you can't be doing the same work in your jurisdiction as the attorneys in California, because a lot of times you can couch these very specific rights in a bigger, broader right that you may have in your constitution.
Now, who qualifies as a victim in a given situation? In most jurisdictions, the legal definition of victim is broad and includes people beyond those who are the direct victim of a crime. For example, surviving family members of homicide victims, guardians of minors, and other selected representatives are included in many jurisdictions' definition of crime victim. However, each jurisdiction is unique, so determining whether a person is entitled to a right requires analysis of both the right and the definition of victim in the victim's jurisdiction. One state might define victim so that the state constitutional and statutory rights are only available to victims of specific crimes, while other states might define the term more broadly to include all victims, no matter what type of crime was experienced. The definition matters a lot. We covered the who, so let's look to the how and when victims' rights attach. Even simplified renderings of a sequence of common events in the criminal justice system look complex. And this process, as we know, can look different and/or use different vocabulary from jurisdiction to jurisdiction. So with that in mind, how do victims' rights attach in a given jurisdiction's criminal justice process? Based on the language of the provisions, rights might attach automatically or attach upon request. Under Oregon's Constitution, for instance, victims have an automatic right to be present at proceedings held in open court when the defendant will be present. As an example of rights that attach upon request, victims in Arizona have a right to be informed upon request when the accused or convicted person is released from custody or has escaped. Of course, attorneys can still seek enforcement of a victim's rights, even where a victim did not make such a request. Here's an example from Arizona. Now that we have addressed the how by looking at how rights can attach automatically and upon request, let's look to the when, because timing is also an important factor. Some jurisdictions may indicate that certain victims' rights attach only after charges have been formally brought against the defendant, such as through an indictment or information. The Federal Crime Victims' Rights Act, on the other hand, is an example of a statute that was intended to apply before criminal charges are filed, including during the detection and investigation stages. Take a look at the CVRA's language here. Narrowing this down to one specific right, restitution is a right that vests at sentencing, but many victims begin keeping track of the expenses they incur as a result of the crime and conferring with the prosecutor or victim advocate before the sentencing stage. That way, their financial losses and their right to restitution can be taken into account for any plea negotiations that might take place. Let's look to Louisiana and Hawaii for additional examples. Louisiana constrains the conferral right to criminal matters in which formal charges have been filed by the district attorney's office. This excludes pre-charging situations, whereas Hawaii's victims' rights statute defines the term case expansively. So the plain language of the provisions demonstrate that victims in Hawaii are entitled to a notification right and a possible consultation right long before formal charges are filed. These scenarios underscore the importance of becoming familiar with the language in the victim's jurisdiction to determine how and when rights attach. But laws without action are just words. So each of our rules is a crucial component in victims' rights work. Why do we need to understand all of this? Because we can ensure that all of these rights have meaning. When victims know to ask for rights in an effective way, their lawyers can make effective arguments in court. Then, courts can enforce those rights. And finally, systems are compelled to comply with them. This is how rights come to have meaning, through work, through action. And this has been Victims' Rights 101.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other Toolkit resources for additional interactive learning exercises like this video, in addition to other tools such as flashcards, tip sheets, and much more. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online form by clicking the Professional Resources tab and then selecting Technical Assistance. Thank you for joining us.